copyright and state sovereignty immunity. Allen v. Cooper decision. On March 23, 2020, the Supreme Court issued its opinion in Allen v. Cooper, concluding that Congress lacked the authority to enact the Copyright Remedy Classification Act of 1990, which permitted that state sovereignty immunity in copyright infringement actions. The CRCA, which sought to remedy alleged state copyright infringement, provides that any state officer or employee shall be liable for copyright infringement in the same manner to the same extent to any non-governmental entity. In Allen, the Supreme Court held that CRCA was not a valid exercise of Congress' constitutional powers under Article 1 or Section 5 of the 14th Amendment, although the opinion leaves open the possibility that a narrow congressional abrogation of the state sovereignty immunity for copyright suits might be constitutional. The immediate practical effect of the decision is that copyright holders cannot sue state governments for copyright infringement without their consent. The decision's broader significance lies in clarifying the limitations on Congress' power to provide remedies for state constitutional violations. The laws of state sovereignty immunity. Because states are separate and independent sovereigns within the United States federal system, they generally cannot be sued in state or federal court without their consent. Although Congress has some authority to abrogate state sovereignty immunity, that is, to enact statute authorizing certain lawsuits against states, this authority is fairly narrow. First, Congress' intent to abrogate state sovereignty immunity must be unmistakably clear from statutory language. Second, even unmistakably clear obligation is effectively only when made under valid grant of constitutional authority. In the 1996 case of Seminole Tribe v. Florida, the Supreme Court held that Congress cannot abrogate state sovereign immunity pursuant to its Article 1 powers, such as the Commerce Clause. Seminole Tribe acknowledged, however, that Congress could rely on Section 5 of the 14th Amendment as a source of power to abrogate state immunity. In later cases, the court established that Congress may rely on the 14th Amendment to abrogate state immunity only if there is congruent or proportionality between the constitutional injury that abrogation legislation seeks to remedy, and that means Congress uses to redress them. In determining whether legislation is congruent or proportional and thus constitutional, court examined the scope of constitutional rights at issue. Second, whether Congress has identified a history and pattern of relevant constitutional violation by states. And three, whether the law scope is out of proportion to a valid remedial objection. Applying this test in Florida Prepaid Post-Secondary Education Expense Board versus College Savings Bank, the Supreme Court in 1999 invalidated the Patent and Plant Protection Remedy Classification Act, the Patent Remedy Act, which purported to abrogate state sovereign immunity for patent infringement cases using nearly identical language as the CRCA. In enacting the Patent Remedy Act, Congress pointed to three potential sources of constitutional authority: the Commerce Clause, the Intellectual Property Clause, which provides Congress power to grant patents and copyrights, and the 14th Amendment. In light of Seminole Tribe, however, parties conceded that Article 1 powers could not support the Patent Remedy Act, and the court thus agreed that the Patent Remedy Act cannot be sustained under either the Commerce Clause or the IP Clause. Instead, the primary issue in the Florida Prepaid was whether the Patent Remedy Act was constitutional under Congress' powers to enforce the 14th Amendment, which, among other things, provides the state shall not deprive any person of property without due process of law. On this issue, the court found that although patents may be considered property within the meaning of due process clause, not all patent infringement by states would violate the Constitution. Rather, state patent infringement violates the due process clause only when infringement is both intentional or reckless, and second, without any adequate remedy under state law. Because congressional records supporting the Patent Remedy Act revealed only a handful of incidents of state patent infringement that did not violate the Constitution, Florida Prepaid held that Patent Remedy Act obligation failed to congruent and proportionality test, which was invalid In 2006, however, the Supreme Court limited central holdings of Semel tried in Central Virginia Community College versus Katz, which addressed whether a bankruptcy trustee could sue to recover certain assets that a bankrupt business has transferred to several state-run schools. The state school moved to dismiss the bankruptcy proceeding on the state of state sovereign immunity, although Semel tried broadly stated that Congress could not abrogate state sovereign immunity pursuant in Article 1 powers. Katz held that 1. Article 1 power of the Bankruptcy Clause should support the obligation of states. History and purposes of the Bankruptcy Clause amounted to a waiver of state sovereignty immunity affected by the plane of the Constitutional Convention itself. In reaching this conclusion, the court relied on the property-based nature of bankruptcy jurisdiction and the Bankruptcy Clause purpose of establishing a uniform federal response to the problem created by the state by state patchwork of insolvency laws that existed before the founding. The dispute in Allen v. Cooper. In 1770, the pirate Edward Teach, better known as Blackbeard, captured a French vessel and renamed her the Queen Anne's Revenge. The next year, that ship ran aground and Blackbeard abandoned her off the coast of North Carolina. In 1996, the private salvage firm Intersol discovered the wreck, and the North Carolina's Department of Natural and Cultural Resources and the department signed an agreement with Intersol to recover it. Intersol, in turn, retained Rick Allen, a videographer, to document the salvage effort, and Allen later registered copyrights in his photographs and videos of the recovery. In 2013, after the department posted some of Allen's images online, Allen accused the department of copyright infringement. The parties settled in this dispute and entered into a settlement agreement. The department posted several videos online that incorporated Allen's copyright footage. Allen then sued the department and named state employees for copyright infringement. The department moved to dismiss the suit based on state sovereign immunity. The district court denied the motion to dismiss, holding that Congress had valid abrogated state and sovereign immunity under Section 5 of the 14th Amendment. On appeals to the U.S. Court of Appeals for the Fourth Circuit, holding that Congress could not rely on the IP clause to abrogate state sovereignty immunity in the light of Florida prepaid, and that the CRCA swept too broadly to be valid legislation to enforce the 14th Amendment. The Supreme Court granted certiorari in Allen v. Cooper on June 3rd, 2019. The decision in Allen v. Cooper. Justice Kagan wrote the opinion on the court, which fellow justices joined in full. The opinion analysis closely tracks that of Florida prepaid, which the court states all but pre-wrote its decision in Allen. First, the court held that Congress lacked the power to abrogate state sovereign immunity in copyright suits under the IP clause, concluding that Florida prepaid was controlling on this point as a matter of stare decisis, given the IP clause covers copyrights and patents alike. If the clause could not sustain the Patent Remedy Act, that it cannot support copyright equivalence of CRCA. And for the same reason, the court roundly rejected the notion that Katz disturbed Florida prepaid analysis on Article 1 abrogation, concluding that everything in Katz is about and limited to the bankruptcy clause and singular nature of bankruptcy jurisdiction. Second, the court concluded that Congress did not have validity abrogate state sovereignty immunity under Section 5 of the 14th Amendment, which grants Congress the power to legislate to prevent and remedy due process violations by a state. The court found in enacting CRCA that Congress had neither identified a consistent pattern of unconstitutional copyright infringement by the states nor tailored the CRCA remedies to actual constitutional violation. The constitutional record supporting CRCA identified no more than a dozen state copyright infringements, most of which were not willful in nature and therefore did not violate the due process clause. Moreover, the legislation record contained no information about the availability of state laws, remedies that could alleviate any due process violation. Justice Kagan's opinion suggested, however, that the result in Allen need not prevent Congress from passing a valid copyright abrogation law in the future, if supported by adequate legislation record and tailored to unconstitutional copyright infringement by states. Justice Thomas wrote simply to note his more limited view of stasis and the question whether copyrights are property on a due process clause, but otherwise join most of Justice Kagan's opinion. Justice Breyer, joined by Justice Ginsburg, concurred only in the judgment on the grounds. Justice Breyer agreed that Florida prepaid controlled the case, but expressed his long-standing view that the court had erred in Florida prepaid and other state sovereignty immunity cases. As a practical matter, the most direct effects of Allen v. Cooper are for copyright holders and users of copyright works. Allen feared that a decision upholding state sovereign immunity would increase uncompensated use of copyright works by states and their instruments, such as state universities, harming the creator of those work economically and undermine the incentive to create provided by copyright protection. Justice Breyer raised this concern at oral argument, musing about whether states could use their immunity to copyright suits to raise funds by getting up a website to show Hollywood movies online without compensation to the copyright holders. It is far from clear that such fears are any more hypothetical. However, that supported North Carolina in foreign part maintain the practical political constraint will prevent states from abusing their sovereign immunity. On the contrary, they argue that state immunity from copyright suits clearly established in Allen may benefit the public by facilitating the public mission of the state universities and libraries who are now freer from fear of copyright liability. The broader legal effects of Allen relates to the scope of Congress' power to abrogate state sovereign immunity. Prior to the decision, whether Katz unsettled the basic legal principles of the Seminole tribe, the Article I power cannot be used to abrogate state sovereign immunity, was unclear. Allen firmly establishes that Katz's holding is limited to bankruptcy context, and the court will not engage in the sort of clause-by-clause Article I analysis that petitioners and Allen had urged. Allen is also notable in that it appears that all 9 justices now accept Seminole tribe as settled precedent, even though a substantial majority of justices, some still on the court, was not yet really ready to adhere to the decision less than 2 decades ago. To the extent that Congress disagrees with the outcome of Allen v. Cooper, it could seek to enact new abrogation legislation more narrowly tailored than CRCA. Allen keeps open the 14th Amendment as a source of application authority subject to the fact specific congruence and proportionality test. The court analysis is Allen suggests that such legislation would stand a greater chance of surviving constitutional scrutiny if 1. The supporting legislation record demonstrates a substantial history and pattern of intentional, unremediated state copyright infringement, and 2. The remedy is limited or at least tailored more closely to intentional, unremedied state copyright infringement.